Criminal Procedure Code 1973, Section 4 of the Criminal Procedure Code 1973 says that CRPC would be applicable for any offence committed under Indian Penal Code or any other law. So whether it is NDPS Act, POCSO Act, IT Act, or it is under environmental offence, company also, or any other, CRPC would be applicable. Then there is section 5. Section 5 of the CRPC says that is the saving if there is some specific provision with respect to the some procedure that about the, because CRPC में आपको whether the offence is bailable, non bailable, cognizable, non cognizable, to whom it is triable, that is shown in the list, that is in the first schedule. So first schedule में दो पार्ट हैं. First part for the offences under IPC, second part for the offences committed and under any other law, and other provisions also there. So section 5 of the CRPC says that if there is any special provision in any special law, so those provision will override. Like here if we see section 77A, section 77B, 70 in our IT Act, so these provision will override the provisions in the Criminal Procedure Code, otherwise the CRPC would be applicable. When you read section 2N of the CRPC, offense, any act committed under IPC or any other law. So section 2N, section 4 and section 5 make it possible that these offenses would also be tried according to the Criminal Procedure Code, and so same way they would be tried. Yes, जो कुछ नए चेंजेस हैं, जो नए प्रोविजंस हैं प्रोसीजर से रिलेटेड, that would be applied irrespective what is written in the Criminal Procedure Code. For the triability, that to whom the case will be will go, before whom the case would be tried. See, IT Act is silent that to whom it is tried, so we have to go to the first schedule of the the Criminal Procedure Code. In the first schedule, the second part with respect to other offences, if the offence to whom the punishment is below 3 years, so any magistrate can try. If the offences is punishable below 7 years, 3 to 7 का जो होगा, so first class magistrate, and then 7 to above, then the other this session judge. So this you have to see from Criminal Procedure Code, whether the offence would be bailable. These cyber offences under our IT Act would be bailable or not. We have this provisions of section 77 clause B, that offences with 3-year imprisonment to be bailable. So जो हमारा section 66 का offense होगा वो bailable होगा. Whether it would be compoundable और नॉट, वहाँ पे CRPC में सेक्शन 320 है, यहाँ पे आपका सेक्शन 77A है. इन्वेस्टिगेटिंग के ऑफिसर कौन होगा, फॉर दैट देर इज़ आवर प्रोविजन 778. अर्लियर इट वाज दैट द DSP, the police officer not below the rank of DSP would make the inquiry, but then it was found very unsuitable because very less number of DSP are posted in the state and the offences are so large in number. So now it is the police officer not below the rank of the inspector. Why this provision of the special investigating officer has to put here? There is a reason about it. Generally when you see if you see the hierarchy, because I was the assistant district attorney, so I was at the rank of this DSP and between SP. So if you see that first or the lowest rank is the constable, okay, then head constable, and generally the investigation even given to the head constable also, not for all offences, for some petty offences also. Then accordingly the through their manuals and their prudence, they distribute the investigation. Here the nature of the cyber offenses are such that the person should be even, who is the person who is appointed as the constable, etc., that the person who has the matriculation, qualification. In some state maybe the 12th qualification. So we need the person who is competent, because competence is very important, otherwise the cyber crime or the offenses would not be investigated properly. And to keep this thing in the mind, section 78 is drafted to make that there would be effective investigation. So with this, I think we have discussed with respect to the procedure also, related to the information technology, which procedure will applicable, normal court to which the court have the jurisdiction. For the IT offense, one can the FIR can be lodged and would be tried by the normal court.